Ma'am Wagas, i-upload natin doon para kung mag-review sila, pwede nilang balikan doon sa pag nag-subscribe sila sa YouTube channel. Okay ba yan, ma'am?
Yes, attorney. Yes, attorney.
Okay. So, how many in the room now?
We are 37 all in all, attorney.
Okay, so for those who do not know me, I have been connected with the Philippine government for 20 years. 9 of those years were spent abroad as a diplomat taking care of our OFWs in Malaysia, in Kuwait, the most difficult assignment in Kuwait, and also in Taiwan. And I have been a labor arbiter at the age of 27. At the age of 24, when I was studying in the College of Law of UB, I was a court interpreter in the City Court of Cebu. So I was a working student. Many of you, I think, are working students. And do not be discouraged. Oh, meron akong narinig na bumabahing, baka merong symptoms. May symptom yan, no? Okay, so I was also connected with big companies like San Miguel Corporations, Petron, Pepsi-Cola, and many other companies. I'm a member of the Board of Trustees of St. Paul University in Surigao, in Manila, in Tuguegarao, in Dumaguete, in Quezon City, and I'm a faculty member of a number of universities. Right now, I am conducting webinar classes for San Beda and also University UE, which produced the second placer last year. Fatima Pahariman, who was my student in labor standards, in labor relations, in labor law review, and even in social legislation. She is also a working student. So for us, malaki na ang ating pag-asa ng mga probinsyano, probinsyana, at mga working student because the result of the last bar examination was the victory of the probinsyano. No? So with so many years of teaching here in UB, I started in 1977. And I told you earlier that Mike Rama was my student as well as the late Serge Remundi. And there were many others who were under me in the College of Law. I was even given the subject of wills and succession. Can you imagine that? I was teaching wills and succession in 1977. But my love really is labor law. Can you see this in your screen? Can you see this?
Yes, attorney.
In the bar examination of 2019, which was released earlier this year before at the earlier stage of the lockdown, only 27.36% pass. So out of every 100, only 27 would pass. For every 10 in the classroom, only 2 or 3 will pass. Can you imagine that? Very, very high mortality rate, no? Very high mortality rate. Out of 7,685, only 2,103 made it. So many are called, but only few are chosen. And again, the top-notchers are from Legazpi, no? And some other places like Palawan, Baguio, St. Louis University. So these are good signs, no? Most of the top 10 come from provincial schools, no? And most of them are outside Metro Manila. In 2018, 22% passed. So that is lower than last year, no? And out of the 22%, 4,000 were first-timers, no? Parang hati-hati, kalahati first-timer, kalahati repeaters. But look at that. Dinuwagas that out of the 4,079 repeaters, only 11% made it. Can you imagine? Only 460 out of 4,000 made it of the repeaters. Medyo nahirapan ang mga repeaters kasi ang mga first timers ang mas mataas ang percentage of passing. That was meron tayong San Carlos, 4 ang top notcher nila sa 2018. Ang isa niyan ay kababayan ko from Ronda, Cebu, si Mark Lee, Agustos D. Natuel. No? Yan, yung number 2 dyan is from our town. No? And we are writing a book together, no, as a co-author, So ito mga inspirasyon lang para sa inyo, yung mga sikat na mga top notcher, Ferdinand Marcos, Florence Regalado, yan. Yan ang mga sikat na mga top notcher. Manuel Rojas, President, first place. Diosdado Macapagal, President, first place. Ferdinand Marcos, President, first place. Sergio Osmeña Sr., second place. Jose Laurel, second place. Elpidio Quirino, second place. Manuel Quezon, fourth place. Si Manuel Quezon at Sergio Osmeña, mag-classmate yan sa UST. And medyo mas matalino si Sergio Osmeña. Ito ang lolo ni dating Mayor Osmeña at ni dating senador. Pero vice president siya. So Rodrigo Duterte, hindi siya bar top notcher, but he is a lawyer. No? Ang mga hindi lawyer, si GMA, si IRAP, si FBR, si Cory Aquino, Ramon Magsaysay, all the rest are lawyers. No? So, nilalagay ko lang dito, Jokno, are you aware that Senator Jokno was allowed to take the bar without taking up law? He did not study law. He was a board top notcher of CPA, number 1, but he was not allowed to take his oath because he was only 17 years old when he topped the CPA. So he just read the book of his father, the late Senator Ramon Jokno, and he topped the bar. Tay sila dalawa ni Jovito Salonga, exactly the same. Pero si Jovito Salonga studied in UP. Ito si Senator Jokno never enrolled in the College of Law. But today, that is no longer. You should take the 4-year course after the 4-year preparatory baccalaureate degree. No? Ferdinand Marcos was arrested and convicted of the murder of Julio Nalundasan. He was sentenced to 10 years in jail, but while he was in prison, he reviewed for the bar, he prepared his appeal brief, and he took the bar, and his unofficial grade was allegedly 98.5, but it was reduced to 92.35 because there were allegations that he cheated. But when he was given an oral exam by the Supreme Court in Bank, he was required to appear before the Supreme Court in Bank, but he could memorize the rules of court verbatim. That is called photographic memory. But today, the law students do not have photographic memory. they have pornographic memory. No. Hilario Davide Jr., the father of Vice Governor Junjun Davide, was a barefoot boy from Kulawin, Argao. He had to walk 10 kilometers to the Poblacion to study. And he was a famous member of both the 1973 Constitutional Convention and the 1987 Commission. He ended as Chief Justice of the Supreme Court. Artemio Panganiban, also Chief Justice, he could not afford the daily fare from Sampaloc to UP in Diliman. So he studied in FEU and he was number 6 in the bar. A guy who flunked the bar in 1993 became number 1 in 1994. So if you flunk, do not lose your hope. You still have the opportunity to top the bar. Claro M. Recto was given the highest grade in Ateneo and in UST, and yet he flunked in the bar because of his handwriting and also because he got below 50 in civil procedure. And after failing in the bar, he wrote a book on civil procedure. And next time, he passed the bar. He was not a bar top-notcher, but he became a famous statesman and public official, Claro M. Recto. Janet Abuel was a single parent from Baguio, working student. He topped the bar in 1998. So Florence Regalado has the highest grade until now, not surpassed. The first female bar top-notcher was Tekla San Andres Siga from Albay and Tabaco Albay. And he is the mother, she was the mother of a senator, Senator Victor Siga. He was my brother in the fraternity. Cecilia Munoz Palma was the second bar top-notcher who became Associate Justice of the Supreme Court. This is just to inspire you. Husband and wife, both top-notcher, became justices of the Supreme Court. Laima, who is now behind bar, was a bar top-notcher. And Indrele was number 11. He got 100% in commercial law. Frank Drilon, 3rd place. Claudio Tihanque, bar top-notcher. His son, bar top-notcher. His nephew, bar top-notcher. All number 1, all number 1. And all ang father and son is from Ateneo and the nephew from UP. And maybe you will be interested to know that the father of Governor Gwen Garcia, Sinoy Pabling Garcia from our town in Dumanhog, was number 3 in the bar exam. And the son, who is now the congressman representing the 3rd district, is Pablo Jan, was a 4th placer. The uncle, who is the brother of Noy Pabling, was also a bar top-notcher, top 10. He's the owner of Sunstar, the family of Jesus Garcia. The brother Manuel Zamora and Ronaldo Zamora, now Ronaldo, congressman of San Juan, were both bar top-notcher. So tonight, ladies and gentlemen, we will now cover what was stated in our syllabus. And we will start with basic principles. Basic principles. If there is one thing that I ask you to memorize, it is Article 13, Section 3 of the Constitution. because this provision of the 1987 Constitution is the basis, the constitutional basis of all the legal statutes that has something to do with rights of labor. For instance, the mandate to afford full protection to labor, local or overseas. Even if you are not within the territorial domain of the Philippines, if you work abroad, still the labor laws of the Philippines will protect you, provided that your contract of employment was processed in accordance with POAA rules and regulations, and it is signed in the Philippines, pursuant to the principle of lex contractus, the law of the country where the contract was signed would apply, even if the employer is the agency is located in the Philippines, the employee was hired in the Philippines but deployed to the United Arab Emirates, the law of the Philippines will protect you. The chairman of next year's bar examination, Justice Mario Victor Leonen, a famous professor of law in the University of the Philippines in constitutional law and political law, was the ponente in the case of Samir International Placement Agency, Inc. versus Joy Cabiles. And this is a very important case. This case, I think, will be asked in the bar examination. It is important this case, understand the principle, and later tonight, I will discuss tonight which is a reiteration of the Supreme Court in Bank. Remember, Joy Cabiles is a Supreme Court in Bank decision. 14 justices signed for the majority, only one dissented, and that was former Dole Secretary Arturo Brion, who was also #1 in the bar examination of 1974 from Ateneo. He was appointed Secretary of Labor, later Associate Justice of the Supreme Court, and he dissented from this decision in Samir. But the majority was very strong in insisting that the legislative branch, the House of Representatives and the Senate, cannot circumvent the very explicit, categorical, and unequivocal mandate of the Constitution to afford full protection to labor. And also denying Joy Cabiles of the equal protection law, because when you are in the Philippines and you are subjected to illegal dismissal, the remedy would be reinstatement with full back wages from the time the wages were withheld illegally up to the actual time of reinstatement, plus interest, and also attorney's fees of 10%. Interest because of the case of Dario Nacar versus Gallery Frames, which was decided under the ponencia of then Justice Diosdado Peralta, who is now the incumbent Chief Justice of the Philippines. He is my neighbor here in the BF Homes, Parañaque, Chief Justice Peralta. And also the former Chief Justice Lucas Bersamin. They always go to the church in the same parish where I am serving as a lay minister, an extraordinary minister of the Holy Eucharist. And I give them the Holy Eucharist, the two justices who are both chief justices. And the three of us were also professors in the University of Santo Tomas, Faculty of Civil Law. And the daughter of Chief Justice Bersamin was my student. She is now the presiding judge in the Regional Trial Court in Las Piñas. So, in this principle of protection to labor, there is no distinction whether you are in the Philippines. Therefore, it was unconstitutional for Congress to enact a law that would lower the back wages to only 3 months. That law, which was enacted twice under the Labor Code, and then later on under the amendment of Republic Act 8042. The Supreme Court was very emphatic, was very firm in saying that the Congress of the Philippines violated the Constitution by enacting a law that would discriminate against OFWs by limiting the back wages to only 3 months. So the Supreme Court declared as unconstitutional that specific provision of in the case of Antonio Serrano versus Galant Maritime. And then later on, in the case of Samer International versus Joy Cabiles, when the lower house introduced again by surreptitious insertion in Republic Act 10022, after the Supreme Court declared it unconstitutional in the provision of 8042. It was reintroduced out, declaring it in public hearing that it was the intention to introduce a irony is that 8042 was entitled as the Magna Carta for labor, and yet there is a provision that discriminates against the OFW. And then the state shall guarantee the rights of workers. You know, guarantee. You just contemplate on the word guarantee. In other words, sinabi ng fundamental law, sagot ko kayo, sagot kayo ng Estado. It's not just the government that will protect you. It is the state. And the state is a community of persons, more or less numerous, permanently occupying a territory and having a government with sovereignty to which the great body of inhabitants render habitual obedience. Can you imagine that? It is the four elements of the state: people, government, they are all mandated to afford and to guarantee, not just to afford full protection to labor, but to guarantee the rights of all workers. Of all workers. Hindi sinabing employees lang, ha? The right to self-organization is not limited to employees. Don't ever believe that there must be employer-employee relationship before you can be entitled to the right to self-organization, because even the self-employed people can form, can join, can assist in the formation of a union for purposes of mutual aid and protection, not for purposes of collective bargaining. So collective bargaining is the necessary companion of the right to self-organization. And the peaceful concerted action includes including the right to strike in accordance with law. We are the only constitution in the whole world. Take note of that, ha, Bisayanyans. Kumbati kamo. We are the only country that has a constitution that enshrines the right to the right to strike. The right to strike. If you read the Constitution of the USA, it's very brief, does not contain any rights of labor. But the Philippines, being a third world country, where more than 65 million are in the labor force, there's a need for the sovereign Filipino people to, so that it is not just stated in the labor code, where it can be amended, where it can be repealed, depending upon the majority of the politicians. But the founding fathers of the 1987 Constitution decided to enshrine this, so that it needs a constitutional amendment to withdraw, to delete, to repeal any of the rights now included in Article 13, Section 3. Peaceful concerted action, which includes the right to strike in accordance with law. So all these rights, I will discuss later in details, but you take note of the right to security of tenure, because this is the most assaulted right, the most abused, the most violated right, the right of security of tenure. Sa pag-hire pa lang ng empleyado to a regular position, gagawing contractual. And in the guise of the exercise of management prerogative. Even if the position entails the function that are usually necessary and desirable to the usual business or trade of the employer. So there is a circumvention of the law, and including also the prerogatives to hire, to fire, to transfer, to promote, to lay off, to discipline. Many of the employers in the Philippines, I am sorry to say, have the tendency, especially now, to use the pandemic as a justification for rash and reckless termination of employment. Of course, under Article 297, which used to be Article 283, the employer is authorized with retrenchment, redundancy, labor-saving device, and even closure. But there should be some basis, both in substance and in procedure, because the right to terminate, the right to dismiss is founded on two due process, the substantive due process and the procedural due process, which you already know from the very beginning. So I am sharing with you some very important provisions and principles, like the principle of social justice. You know, all social legislations are enacted or were enacted in order to implement social justice. The word social justice, the phrase social justice, has been repeated more than 10 times in the Constitution, even in the Declaration of Policy in Article 2, the Declaration of Fundamental Principles and Policies, the phrase social justice, until Article 13. In fact, the legislative body is mandated by law to give priority to social justice legislation. What is the purpose? It is to make sure that the forces in society, as defined in Kalalang versus Williams, that the law should be humanized and the social forces in society should be more or less equalized. Equalization, humanization, so that justice in its most secular signification may at least be approximated pursuant to the time-honored principle of salus populi suprema est lex. So if you think of the law of recruitment, why is the law of the recruitment very protected of the OFW? It is because of social justice. That is the rationale. That is the philosophy. That is the good sought to be attained to, and there are evils sought to be avoided because of the need for social justice. Social justice in wages, in benefits, social justice in disease and death, protecting workers' health, safety, and welfare, especially in the light of a pandemic globally. There's a need for the state to flex its muscles. I am just telling this to you, reminding you that the philosophy of labor law is social justice. Para bang mangutanang, ano maning gibuhat maning balaura? It's not enough that you know what is the law. You should think deeper and say, what is the philosophy behind this law? What is the good sought to be attained? And the evil sought to be avoided. That is how to study labor law. And if social justice is the purpose, that is the target, that is the destination, that is the goal, the vehicle used, that is police power. Police power is the vehicle used by the state to achieve the goal, which is social justice. Are you following me so far?
Yes, attorney.
And then I want you to master all the rights of labor and to balance it with the prerogatives of management and then the power of the state. The power of the state to enact laws, that is in Kalalang versus Williams. Police power is done through the enactment of laws whereby property rights can be impaired. Even personal liberties can be sacrificed for the sake of the common good. That is social justice. Justice for society. So the rights of an individual can be sacrificed by the state for the greater good of the greater number. So the power of the state is to balancer. How does the state balance? By enactment of laws, by issuance of regulations, by adjudicatory function, and by promoting unionism. Because it is important that the workers should be united so that they will have a bargaining leverage before the employer. And that is because the state values the workers. The state is mandated to afford full protection to labor. So, in the case that I have discussed in my book of labor law, the title of the book is The Ultimate Labor Law Review Compendium for Bar Excellence with Effective Bar Strategies and Techniques. Nako, pag meron ka kopya nitong libro na ito, parang nasa ganghaan ka na sa langit. Pag dili ka musulod, problema na nimo kay ikaw na naggunit sa yawi sa kaharian, no? Kaning mga tao nga dili mukuha aning libroha, galit sa sarili nila. Because this is the answer to your questions. Lahat ng gusto mong malaman nandito na sa libro. So we will take that up. That case whereby the state acting through the Secretary of Labor issued an order. This was Secretary of Labor Franklin Drilon issued a ban against the deployment of female workers to Japan, because there was a time when sending women to Japan was the way by which the beautiful women from the province can attain certain degree of raising their status, improving their economic and social status in society. So it was found out that this business of sending women to Japan was abused by the recruiters. And in fact, it was a front for prostitution, na magpadala tayo ng mga babae sa ibang bansa, pagkatapos sasabihin doon na ipadala as a singer, nga di man makamaumukanta. Makamao na mugunit sa microphone, pero dili makamaumukanta. Nga nga nung magpadala matag singer nga di ka maumukanta. Mauna nga, kana di ay usara na kapag takuban. Isang pamaraan na para ma-justify ang pagpapadala ng mga babae doon sa Japan. So ang sabi ni Frank Drilon, isang matapang na Bisaya na taga Iloilo, na classmate ni late Senator Miriam Defensor Santiago, sabi niya, I am exercising the police power of the state. I am issuing Department Order number 1. Department Order number 1. Remember, Drilon was Secretary of Labor during the time of FBR and even towards the end of the term of President Aquino. And that ban was attacked. The court to question the validity of that order, department order, that Secretary Drilon, first of all, exceeded the bounds of his office, because that is in effect amending the Constitution. The Secretary of Labor cannot amend the Constitution. He is legislative. He cannot come up with a law that will prohibit the sending of women to Japan. And so the Supreme Court, with the late Justice Abraham Sarmiento, an icon of human rights and a delegate to the 1973 Constitutional Convention, the Supreme Court said that the order of the Drilon was a valid exercise of police power. And then the other grounds used by the petitioner was that the order was an impairment of contracts that were already signed. That some female OFWs already signed their contracts, and this order is an impairment of that contract and therefore null and void and must be declared so by the Supreme Court. But the Supreme Court refused and upheld the exercise by Secretary Drilon of the Secretary Drilon of that order. So, and the other reason also is the order of Secretary Ringlod was a violation of the Equal Protection Clause. Why? Why prohibit only the women? Why not the men? Yung mga babae, bawal magpunta sa Japan. Unya ka ng mga bayot, nga nang padoo man na dito. O, dili ba na violation sa equal protection? Mao na nga, niingon ng Supreme Court, no. It is based on a valid classification which is germane to the purpose of the law. Tama ha, pagka ang Supreme Court papabor sa iyo, may reason talaga eh. Meron pang isang ground that violates our rights to travel. Oh, hindi naman kami makapunta sa Japan kasi pinagbawalan mo kami dahil dyan sa order mo na yan. But the Supreme Court said that the police power is superior to your individual right to travel. The police power is paramount. It is the duty of the state. No? It is the duty of the state to protect you even against your own will. Limbawa, may mga OFW na tatawid sa Sandakan, sa Malaysia, dadaan sa Tawi-Tawi, tapos magtrabaho doon. Eh, hindi ka pwede magtrabaho kasi tourist lang ang visa mo. O wala nang visa, kailangan pagpunta sa mga ASEAN countries. But when you visit as a tourist, even if without visa, you are not supposed to work. So if you find engagement as a worker, you violate the law of the host country, no, the immigration law, and you can be arrested. There are many Filipinos who are languishing in jails in the Middle East and also in Malaysia. So the state can protect you even against yourself. The state does not need your consent to be protected. Hindi man kailangan na mananghid ang state ni mo nga, pwede ba, Voltaire, I will protect you? No. Whether you like it or not, Voltaire, I will protect you. Parang parents patre. Yung bang parents mo nanghihingi ng pahintulot sa iyo pag sinasabing proteksyonan ka? Parents patre. Ha?
Wala, attorney. Mo protect always.
Mo lagi protection. Kailangan yun na, Voltaire, you need protection. Kaya mag-ingat ka, no? If you cannot be good always, you need protection. And the state will give you the protection, no? Even if you do not like the protection to labor as enshrined in the Constitution, that does not depend on the consent of the protected. That you take note of that. Kahit ba yung mga workers pa magsasabi, hindi namin kailangan ng protection, gusto namin magtrabaho eh. Bibigyan ng kontrak. Pag pinatay ka doon, tulungan ka pa rin ng gobyerno. Whether you are documented or not, it is the duty of the government to help you. No? Okay. Ito the state's full protection does not mean oppression of capital. Ito naman ang very delicate balance na kung ang protection mo naman, naghinobra ng protection mo, sobra-sobra na, to the extent of killing the ghost that lays the golden egg. Limbawa, isang empleyado nagnakaw, he is caught in flagrante delicto. Pareho nung isang nurse na itago natin sa tunay niyang pangalan na si Maria Teresa Sanchez na nag-uwi ng mga supplies from St. Luke's Medical Center. Sabi, 20 years na ako dito, ngayon lang ako nakasuhan. Tapos hindi naman na-consummate kasi nahuli ng gwardiya. So, masyado namang harsh yung penalty of dismissal. But, you know, is a violation of trust. Ito yung LOTAC, LOTAC, loss of trust and confidence. So, how can you continue employing a person that you do not trust? Kaya, Voltaire, kailangan talaga yung trust kasi pag walang trust, walang proteksyon. Di ba?
Yes, attorney.
Tandaan mo yan, ikaw lang ang nakikilala ko, kaya ikaw lagi kong tinatawag, ha?
Yes, attorney.
Meron bang karyon dyan? Yung karyon, meron ako nakita, karyon. Ang karyon, taga Barili yan. Meron ding karyon sa Runday. No? Pero si Attorney Ernesto Carrion, nagiging labor arbiter yun, taga Kwan yun taga Barili. No? Ayan, nakita ko rin, Villahermosa. Anong Villahermosa? Mayaman yan sa Dagit. No? Tahimik lang siya. So in the case of Philippine Association of Service Exporters Incorporated versus Honorable Franklin Drilon in Bank, June 30, 1998, Justice Sarmiento, a ban of deployment of female OFWs to certain country was upheld by the Supreme Court as a valid exercise of police power. Principle number 3, the state's fall protection means balancing. Balancing. Kailangan yung bang, are you aware of the Latin maxim, sic uteri tuo ut alienum non laedas? Use your right in a manner that does not violate the right of others. So, if you are an employer and you have the right to terminate employment, you have the prerogative to fire, but you cannot use that right to violate the right of security of tenure. In other words, you always remember Article 19 of the Civil Code of his right, and in the performance of his duty must exercise justice, give everyone his due, and observe honesty and good faith. Must act with justice, give everyone his due, and observe honesty and good faith. So when have to do it, what is due, which is due process, and observe honesty and good faith. Merong isang batas na magamit niyo sa lahat ng subject at yan. Pag naubusan na talaga kayo, wala na kayong masabi, gamitin niyo yung Article 19 kasi pwedeng magamit yan sa lahat ng situation. Di ba? Reserve ninyo yan. So, labor laws are means of balancing. Labor laws range from hiring to retiring, and it includes the labor code and other civil special laws, and it is 7 books. Itong pinapakita ko sa inyo. Can you see this, ladies and gentlemen?
Yes, attorney.
Makita ninyo yan?
Yes,
Okay?
po.
Number
Yes,
1,
attorney.
pag sinabing the state afford full protection to labor, kung binisayo na, imo nang panalipdan ang mga mamumuo. Against whom? That begs the question, against whom? Your answer, against unscrupulous employers, against dishonest recruiters, against traffickers, yung trafficking in person, against predators. Kasi ang mundo, sabi nga ni Carmi Martin, ang mundo ay isang malaking kiyapo. Ang daming mandurokot, ang daming mangingilad. Para ba ni karbon o tabuan ba? Daghang kayong mangingilad, na daghang mangunguot, daghan ba nga nagkukunwari nga mutabang nimo. So we have to protect these employees who are the probable victims of the predators. At ang mga predators niya, nakalinya na yan, yung mga employer na nandadaya ng minimum wage, yung mga employer na nandadaya ng overtime pay, yung hindi nagbabayad ng 13-month pay, yung hindi nagre-remit sa SSS, sa PhilHealth, Pag-ibig. At saka yung ginagamit yung kapangyarihan to dismiss recklessly without due regard to the security of tenure, which is a constitutional right. Can you imagine? Constitutional right ng workers yan versus a management prerogative. The management prerogative arises from Book 2 of the Labor Code. Ano yun? The law on property and its modification. If you own the business, you have the right to hire the people to run the business. You can transfer them, you can promote them, you can lay off in case of financial difficulties, and you can also discipline and dismiss them when there is a just cause, but you have to give due process. So, therefore, the first protection of labor is really against this kind of people. The second one is, can you protect, do we have to protect labor from the union when the union is supposed to be the protector? Bakit ka nagtayo ng union? Because you want to be strong. Parang fraternity yan eh. Parang asosasyon yan. Pero kung ang sarili mong union ang umaapi sa iyo, when the protector becomes the victimizer, para itong mga pulis eh, kung ang mga pulis is supposed to be protecting citizen, nangyari sa Amerika, pinatay si Floyd, itim, racism, police brutality, nangyari sa UP Lahog. Yan ang mga example na yung tao na pinagtiwalaan mo, ang union is juridical personality. Pinagtiwalaan mo mag-protect sa iyo kung siya naman ang mangubra ng union dues na sobrang laki. Walang written authorization ang members. Walang resolution na pinas in a General Assembly called for the purpose. So, the union becomes the oppressor. Makipagsabuatan pa yung union with management to use the isang empleyado hindi bumoto doon sa officer na nanalo. Ang majority ngayon, pag-initan yung minority employee na yan, makipagsabuatan sa management yung use of the union security clause as an instrument to deprive the employee of his security of tenure. So the state will afford protection to labor. So the union becomes the victimizer and the state becomes the protector. Now, the government. Why is the state protecting the worker against the government? Di ba government is an element of the state? Kung halimbawa ang labor arbiter, meron siyang deadline to decide a case. Pag-appeal from the regional director, money claims less than 5,000 pesos under Article 129, meron lang siyang may 5 days to appeal, and then 10 days. The labor arbiter has to decide days. sa Republic Act 8042, basta kaso ng mga OFW, bibigyan ng priority, binibigyan ng deadline ng mga arbiter. Hindi pwedeng patagalin yung kaso because any delay is a form of oppression. So the state now will come to help the workers against the ineptitude, the laziness, the negligence, the lack of care, attention, prudence, commitment on the part of public officials who are sworn to protect labor. That's why corruption, graft and corruption is a ground for filing an appeal from the decision of the labor arbiter to the NLRC. There are grounds like grave abuse of discretion, serious errors in the findings of facts, pure questions of law, and the last is graft and corruption. Kung ang isang arbiter ay kinokorrupt ng management, kung halimbawa si si Attorney Carion magiging labor arbiter, tapos mag-appear doon si Attorney Voltaire, sabihin na, classmate naman tayo, pagbigyan mo ako dito, ganyan. Meron tayong 1 million dito, hati tayo. Kita mo yan. Kung napatunayan ng empleyado yan, isang affidavit lang sa ombudsman yan. Pag after hearing, found guilty, wala. The state will protect labor from government officials who are not only lazy, corrupt, negligent, and betraying the trust of the people. Are you following me so far?
Yes, Attorney.
Yes, Attorney.
Yes,
meron ba
Attorney.
kayong natutunan sa akin na hindi pa masyadong
Yes, Attorney.
Yes, Attorney.
malinaw sa isip nyo o alam na nyo lahat ito? Ako lang talaga naghanay dito. Gihanay ko ni tanan. Ako rin gahanay. Number 4, unethical lawyers. You have taken legal ethics. At under Article 110, Book 3 of the Labor Code, pag money claims, only 10%. Kung ikaw maging abogado ka, tapos manghingi ka ng attorney's fees na hati-hati, kalahati ang mapunta sa iyo, kalahati mapunta sa manggagawa. That is unethical. That is a ground to discipline you by the bar. And you can even be disbarred. So, the state will protect the workers against unethical lawyers. There are so many instances. There is a case of Wilfredo Taganas. If you will Google that, Wilfredo Taganas, an ethical lawyer na disiplina ng Supreme Court dahil sobra yung hinihingi sa mga manggagawa. Meron nga isang manggagawa doon sa Negros Oriental na sagasaan sa truck ng tubo. Tapos lumapit sa abogado dito sa Cebu. Sir, tabangi ko sir, kay naputol akong paa. Giputol na lang yun, kay nasagasaan sa ako ang truck. Manghingi tayo ng workmen's compensation sa Book 4, employees compensation, partial disability. Yan, niingong abogado. Unya, pila may bayad mo na ako. Sir, ayaw lang sa akong panil nga karon kay wala man ko ikabayad nimo. Ilista lang tanang gasto nimo. Unya, kung unsay mabilin, tungaon lang nato. Nya gipapirma giniya tong complainant, gipapirma ni pirma sa complainant kay kanigong watay nahot nga ikahatag sa abogado. Nya karon pag abot na sa award, ni award lang pod ang labor arbiter og 70,000 pesos sa putol nga paa. Unya karon gipatawag na niya ang complainant, ari deredong kay nadawat ng kwarta ato na ning kwintahon. Gilista niya tanang gasto niya. Gibutang dito sa kalendaryo, sa likod sa kalendaryo, gibutang dito. Doon ay Colgate, doon ay bayad sa pagplansa sa barong. Niingon ang komplena, nga nung gi-appeal man ni mo, Sir, Colgate. Yung, o mag-hearing di ay ta, dili ko manutbrush. Niya ka ng barong, Sir. Ang mo appear ko dito nga, dili ko magsud og barong. Kanang pagplansa, i-charge gina dato kay mo man isabot na to. Ya, pag abot man ang gasto og 30,000, di 40,000 na lang ang nabilit. Katong 40,000 mo ito gitungan lang, gitagaan lang ito sa abogado og 20,000. Sa 70,000 nga award na 20,000 na lang dawat. Makahila ko dito sa 70,000 nga award ang imuha 50 man, ako 20 lang. Kinsa mang duha na to naputlan og paa, sir? Mura mag-ikaw mo naputlan. Mo na mo example, the state shall afford protection. Kung gikiha katong abogaduha, dili man to tagayobe. Kaya ang tagayobe, manggiloyon mga abogado, mahimo mga dili bayran. Ako, kapila na ko katabang, wadyo ko bayri. Nakadawat nagdako. Naluoy ng ang Ginoo ra mahibaw na, no? Pag ikaw naisahan ka ng isang tao, ang ibang tao ang magbayad sa iyo. Kasi ang Panginoon hindi natutulong. So the state afford protection to labor against unethical lawyers. Itong number 5 ang pinakamatindi. Ito ang masabi ko sa inyo. Kung ang isang manggagawa pumirma ng quit claim, waiver, resignation, out of fear, out of lack of knowledge, yung bang merong gross misrepresentation, may threat, merong intimidation, may coercion, merong deceit. Ngayon, meron na, the best evidence is the quit claim. Kung sa civil law yan, kung magkaso, sabihin lang ng abogado, Your Honor, I move to dismiss the case because the best evidence is the document. The document said that he waives his right because he has already received the consideration. So on this ground, the claim has already been satisfied and this case is without merit. It should be dismissed. But in a labor court, that will not be given due course because the testimony of a worker can even override. At this point, we recognize the presence of our beloved Dean, Dean Joseph Joseph Torregusa. Alam mo ang mga Joseph, mga buutan ka na. Oh.
Thank you, USEC.
Oh, mayong gabi kay
Mayong gabi
I'm happy that you are taking up masters. Soon you will be a doctorate in saang university ka nag-take up din?
San Beda, sir.
By webinar?
I started last 3 semesters ago, but it's overtaken by COVID, so we're doing our classes now online. Unfortunately, one of my subjects, national security, the schedule falls at the same time as your online review class.
Never mind. Kasi yung subject mo, national security, napakaganda yan because of the anti-terror bill.
That's why.
Napakagandang pag-usapan yan. It is the conflict between the power of the state and the right of an individual.
Maybe one time, if you can hold a sort of a special lecture or a seminar on anti-terrorism bill for us.
Okay.
I know you're the best man to educate us on national security.
Yeah, I do not claim expertise on political law, but I can handle that because I am also a reserve colonel in the armed forces because as I was commissioned by the JAGO. I have a master's degree in National Security Administration. Okay,
right.
so very good.
After your labor review class, maybe we can schedule another time for this special topic.
Yes, I told them then that on sometime in October I will be lecturing in San Carlos because I was asked by Villasis Law Center in coordination with Dean Joan Largo. I have a schedule Saturday whole day and Sunday whole day. So I plan that the Monday following I will pass by the College of Law of my alma mater, and I want to meet the members of this class, in person, so that I can give a special lecture also in person by way of a symposium.
That's great. If face to face will be allowed by then Attorney Darchi, let's calendar it.
Yes, Dean.
And make the necessary arrangement.
By October, wala nang COVID.
Wala nang COVID. Hopefully, sir.
Let us claim that with the Holy Spirit.
Yes, sir.
When we pray, we believe, because you ask and it shall be given to you. You just ask and it shall be given to you. No? So,
right.
If I may continue, Dean, can I continue?
Please.
Okay.
Thank you kayo,
So
sir.
Huh?
Sorry kayo, I cannot stay up to the end. I also have to attend to my own class.
Kahit konting pagtingin. Kung kahit konting
kayo, ha?
Basta ikaw for the sake of the students and the graduates, no?
Lagi.
Mohalad ta sa
that's your enduring legacy.
Okay, di man ta kahatag kwarta, wa man tay kwarta, kani serbisyo lang, no? Okay?
Okay, sir. Salamat kayo.
As I was saying, the most important protection by the state in favor of the worker is against the worker's own ignorance. Ignorance na of foresight, lack of skill. Now, in the bar examination, you will be asked to make a ruling. Is the waiver reasonable and just, or should you annul the waiver? That is a very difficult question. Do not rush, because the principle is not all waivers are invalid. When a waiver is validly entered into, you have two conditions. Dalawang kondisyon hanapin mo. You should remember the elements of a contract. You remember Book 4 of the Civil Code? What are the elements of contract? Consent, object, and consideration. Correct?
Yes, po.
So sa waiver, ang una mong tanungin diyan is first yung extrinsic validity is the consent. Was the consent freely given? Was there a meeting of the minds? Was there no vitiated consent? Was there undue misrepresentation, undue influence? Yung mga coercion, force, intimidation, deceit. Because if the facts of the case stated that there is this factor, even one of these factors, you can say that the consent was not freely given. This so-called contract by adhesion, you remember that, Dinwagas? Contract by adhesion? When the only participation of the worker was to affix his signature, ano mga trabahante in town sa construction nga halos dili na makamaumuperma, unya tagaan mo quit claim nga parting nindutang mo in English, parting Unya mapruibahan nga katong tao nga ni pirma morala tog buta. Ngaywa makasabot siya ang gipirmahan tungod kay sa iyang panginahanglan, yung dire necessity. Your child is in the hospital. You need blood, no? And you have to buy the blood. So you need the money. Perma ka, bisa ko unsay permahon basta na ay that consent was not freely given. It was taking advantage of the situation. Kaya kayo, lalo na kayong mga lalaki, huwag kayo mag-take advantage sa mga babae. Tandaan mo yan, Voltaire at saka Attorney Carion, no? Yung mga babae na nangangailangan, lubhang pangangailangan ng babae, pagkatapos mag-take advantage kayo kasi vulnerable siya. Bagong namatayan ng husband, byuda, batang-bata, tapos take advantage nyo. Mananagot kayo sa Panginoon yan. Because vitiated ang consent niyan. Hindi talaga kayo mahal niyan. Parang ginagamit na rin kayo dyan para panakip sa kanyang pangangailangan. So wag niyong gamitin yan. Sa labor law, never use your knowledge. When you become a lawyer, do not allow your client who is a powerful businessman to use you as a lawyer to coerce, to deceive, to exercise certain force or coercion over a worker because napakalaki ang gaba ana, no? Gawa sa gaba, pag yan ay makarating sa Supreme Court, that document will be set aside because of lack of consent. Yung pangalawa, yung intrinsic validity, yung consideration. If the consideration is grossly disproportionate, for instance, 500,000 yung dapat niya matanggap, pinatanggap mo lang siya ng wala pang 100,000. Merong decided case, I don't know, Attorney Wagas, if you're aware, halfway. Yung the law on discrimination is not illegal per se. Huwag ninyong isipin na lahat ng discrimination ay bawal. Meron talagang discrimination. Halimbawa, pag mag-conduct ka ng pre-employment examination, tapos 10 ang kumuha, disqualified yung 6, 4 lang ang qualified. You are discriminating against the others. But that discrimination is allowed by law. Kasi mamimili ka, may the best man wins. So, kung halimbawa, sabihin mo, Attorney Wagas, we are recruiting a new librarian for the UB Law Library. But one of the qualification, you must be a law graduate of UB. So that is also discrimination, but is that illegal? No, that is not illegal. Wala pang COVID. Only graduates of UP, Ateneo, LaSalle, all others need not apply. That is discrimination. But is that illegal? No, that is not illegal. Not all discriminations are illegal. Not all are disallowed. Only when it is based on gender. Kung sasabihin, bawal tayo mag-hire ng LGBT. Hindi pwede yan. Doon, nung araw nung bata pa ako, Atty. Wagas, doon sa aming bayan, merong pare nagsabi, makinig ka nito, Voltaire, ha? Ang sabi ng pare,
Yes,
kamong
attorney.
mga bayot, dili gyud mo makasaka sa langit. Ngayon pare, kamo daw mga bayot, dili mo makasaka sa langit. Nasuko ang mga bayot, oy. Nasuko ang mga bayot na sa father. Mali ba yun kasi mong gisulti? Kami mga bayot, kami no'y mauna maadto sa langit. Baka mauna pa kami sa imo.
Mag-decorate na, attorney.
Oh, maulagi. Kaya nga nung mauna mo, kinsa may mo decorate. Oh, di ba? Mauna nga on gender. You cannot discriminate. Sabihin na itong posisyon para lang sa mga lalaki to kasi kailangan dito, kailangan umakyat ito. Meron ng pilot mga babae, may mga general babae. Walang magagawa ang lalaki na hindi kaya ng babae. Correct? Karamihan, alam nyo, Atty. Wagas, noong panahon namin, isa lang talaga ang babae sa seksyon namin. Kaya siya lang ang muse. Pero ngayon, almost one half, more than pa ang karamihan mga babae ngayon, mga bar top notcher, tinan mo, mga bar top notcher, last bar, number 1, babae. Number 2, babae. Nako, kasi sobrang focus sila eh. So we cannot discriminate based on gender, race. You cannot say that this position is only good for expats or good only for Filipinos. Except kung pareho sa hearing kanina tungkol sa Filipino citizen ni Gabi Lopez, no? But that is not employment. That is ownership of a mass media company, no? Itong religion ha, yung mga ibang company gusto mag-hire na mga iglesia kay daily ikaw na mo-join ng union. But you cannot declare this as a policy. Hindi pwede yung sabi na Katolik ko lang. Sa San Beda nga, daghan mga Muslim nga estudyante, isipin nyo ha, I think we have a Muslim also participant of this webinar, attorney. Meron ba?
Attorney.
So,
I think
kung
so,
sino
attorney.
man yung Muslim na yan, assalamualaikum na lang. Assalamualaikum warahmatullahi wabarakatuh. Yan. Anong ibig sabihin yan? Ang mga Muslim, pag assalamualaikum, sagutin mo yan ng alaikum assalam. Peace be with you. Di ba? Hindi mo sagutin ang malay ko sa iyo. No? Assalamualaikum. Alaikum assalam. Yun. Peace be with you. So, walang pinipili tungkol sa relihiyon, tungkol sa sekta. Meron pang dagdag ngayon age. Bawal na ngayon, attorney, na mag-advertise ka na wanted secretary not more than 35 years old. Kasi before you can see that kind of advertisement, magbasa ka sa Sunstar, sa Freeman, di ba? Not more than 35 years old. Bawal na ngayon yan. Pag ikaw ang HR manager, kahit 85 years old mag-apply sa iyo, huwag mo sabihin, ayaw ka namin tanggapin, 85 ka na, hindi ka na makaakyat dito sa Rivera Building. Hindi ganon. Lahat ng applicant, kahit 85 years old, bigyan mo ng application form. Tapos bigyan mo ng exam. Sabihin mo, gumawa ka ng PowerPoint. Siyempre, hindi siya marunong. Bagsak siya, hindi dahil sa edad niya, pero dahil sa kanyang skills, kulang sa skills. Oh, who knows kung marunong yan. You cannot disqualify a person based on age. Ang panglima is based on unionism. Because unfair labor practice when you discriminate on the basis of union affiliation. Kaya it is illegal to state in the application form, have you been a union member? Are you a member of the union? And then use the answer as a basis for determining fitness. That is not allowed. No? So 5 na yan. Gender, race, creed, age, and union affiliation. No? So, if there are no questions, we will proceed to the basic term. No? When you are born into this world, ladies and gentlemen, you are a person. But when you reach the age of 15, the age of 15, you are a member of the labor force. If you are not in school, so worker, even if you are not working, you are considered a part of the labor force. The moment you enter into employer-employee relationship using the four-way test of hiring, paying of compensation, control, and dismissal, you become an employee. And as an employee, you may be casual, you may be probationary or regular. So casual or seasonal, this is defined in Book 6 of the Labor Code, except fixed term employment, which is by jurisprudence. In the case of PNOC Energy Development Corporation in Tungunan, Leyte versus the NLRC, Justice Eduardo Natura, as ponente, gave a lecture on the different kinds of employment. And definition of regular employment, and also casual and project employment, no? Which was reiterated by Justice Arturo Brion in the case of Universal Robina Sugar Corporation versus NLRC, where Justice Brion created a new kind of employee which is called regular seasonal. Yung bang magtrabaho lang during milling season, magtrabaho during planting season, then pag natapos na yung season, wala na silang trabaho. But in the next planting season, they have the right of first refusal. They have already attained a limited security of tenure. So management cannot hire any others because these people who have been repeatedly hired became what is called regular seasonal. In the case of Universal Robina Sugar Corporation versus NLRC, written by Arturo Brion, Justice. Then at this point in time, you know who are rank and file, who are supervisory. Supervisory is defined in Book 5 in Article 219, Paragraph M, confidential. Confidential employee is defined in Article 82, as well as managers, Book 3. Executives are the top managers. The board of directors are not employees. So they do not enjoy the rights of employees, the board of directors, because they are the representative of the owners. So in a way, they are also part of the employer. Union, when you organize a union, you have articles of incorporation, you elect the officers, you are a union, but you are not yet an LLO. You are not an LLO unless you are registered. So it is the registration that elevate your status from a mere union up to an LLO. And then when you win in the certification election, or you are voluntarily recognized by management, you become a SEBA. SEBA is sole and exclusive bargaining agent. And when you sign a collective bargaining agreement with management, you become a party to a CBA. So you see, this is metamorphosis. Like larva, pupa, chrysalis, papeles, butterfly, di ba? Dadaan ka ng proseso. So, sa tanang law professor sa tibuok kaliputan, ako ra nagbuhat ingon ani ba? Can you see this? This is not the solar system. Nag-umpisa, person, worker, employee, union, legitimate labor organization, SEBA, pumirma ng CBA, tapos tinanggal ng management, na biktima ng unfair labor practice, naging complainant sa kaso. Kung mag-file ng notice of strike, nagiging striker. Binalikan sila ng management. Dinismiss sila. Or kung hindi dinismiss, siniparate. By the way, yung term ninyo, gamitin niyo yung word na dismissal kung ang ground ay just cause. Meaning serious misconduct, insubordination, fraud, gross negligence, crimes, ang gamitin niyo dismiss. Pero kung ang mode ninyo ay authorized cause like retrenchment, redundancy, labor saving device, ang term na proper is separate. That's why there is separation pay. Are you following me? Do you hear me? Wala na
Yes,
yata ang
po.
tao.
Yes, attorney.
Yes, attorney.
44
Yes,
kung
attorney.
Oh,
Yes, attorney.
nakita ko kanina,
attorney.
kanina 45, ngayon 44 na lang niya na may balaod si Kim Cho. Bawal lumabas sa classroom. Oh. Ini lumabas sa classroom. Oh, karon 42 na lang, no? Siguro doon na to ilakaw. So again, I created this model, no? This one-page presentation of all the jurisdiction of the different offices in the Department of Labor. And when we come to the proper session later on, when we come to procedures, we will take this up one by one based on the nature of the case, where to file, where to appeal, Rule 65, Rule 45. Nandyan lahat yan. So, is there any question? Ito yung sinabi ko kanina, the Department of Labor's ban on deployment of female OFWs to certain countries was upheld by the Supreme Court as a valid exercise of police power. These are not new cases, but it is landmark and in-bank cases will never expire. Remember that the chairman this year is an expert in constitutional law. Therefore, you have to expect questions about police power, about validity of issuance by the executive. No? Kailangan matalino kayo. Tingnan ninyo kung si Justice Bernabe yan, nakaraan, Regional Trial Court yun, mahilig yun sa mga procedures. Pero ngayon, ito si Justice Leonin, hindi ito dumaan naging judge. Professor ito eh. From the classroom direct to the Supreme Court. Hindi dumaan ang Court of Appeals or RTC. Di pareho kay Peralta na RTC, nagiging Sandigan Bayan, nagiging Court of Appeals, Supreme Court. Ito si Bersamin din, galing sa RTC. Hanggang Court of Appeals, na punta din sa Sandigan Bayan. Pero ito si Marvic Leonin, professor talaga ito at saka itong pinakabata. Mag-retire na lang lahat ng justices. Yan na maiwan dyan. No? Those who seek to sacrifice the rights of the workers in pursuit of profits cannot use the Bill of Rights as a weapon to defeat the overriding police power of the state. Kaya yung anti-terror bill can be justified as police power. Pati yung human rights minsan nasa sacrifice because of police power. Police power is inherent and need not be explicitly provided. Inherent yun eh. The ban is deemed not violative of Equal Protection Clause. The ban is deemed not to impair the right to travel, and it does not violate the non-impairment clause. Tama? The police power of the state cannot be subordinated to the businessman's freedom to contract and to the non-impairment clause. These are very big pronouncements by the Supreme Court, which you have to highlight. You have to highlight and you have to remember, because these are very important principles. In the name of police power, the state can regulate the business of medical clinics. Ito, another case ito ha. This is, labanan ito ng dalawang klaseng medical clinic eh. Kasi ang negosyo ng mga medical clinic, lahat ng mga OFW dadaan sa clinic ay sinubject ng Secretary of Labor to regulation. Kasi sobra-sobra na yung pinapaningil nila, and ang sabi ng Supreme Court, yung right ninyo to earn profit is subordinate to the police power of the state in pursuit of social justice. Kaya tumahimik kayo. Ito, si Art Brion, ang ponente, in bank din ito ha. Wala itong dissenting opinion. Mabigat itong kaso na ito. The regulation by the state of the operation of medical clinics is held by the Supreme Court as a reasonable exercise of police power, because there is a standard that is reasonable and it is applied uniformly to all similarly situated establishments. So, is there any question? Ayan, mga hot topic ha. Ito, bibigyan ko na kayo ng mga hot topic next Monday nating kwan. Ito yung mga provision na napakahalaga. Halimbawa, ito, tanungin ko kayo. Assignment ninyo ha. Kayo, what are the 3 kinds of managers under the labor code? Yung manager under Book 3, excluded from overtime pay. Yung manager under Book 5, not allowed to join unions. At manager in Book 6, yung loss of trust and confidence. You distinguish the 3 kinds of managers because they are not the same. You can be a manager under Book 3, and yet you are not a manager in Book 5. Do you realize that, ladies and gentlemen, when you studied labor law, that there are 3 kinds of manager? Did anybody, any professor tell you that you have to remember the 3 kinds of managers? Huwag na niyong sagutin yan, makasama pa tayo ng loob. No? You have the right to remain silent. Ang pinaka-importanting book sa labor code ay Book 6. Because there will cases where there is no question about illegal dismissal. So yung Book 6 is only composed of 10 articles. If you have only 10 minutes before entering the room in the bar examination, you read Book 6. For sure, there will be 2 or 3 questions about illegal dismissal. So you have to master serious misconduct, insubordination, fraud, gross negligence, and crime against the person of the employer, immediate member of his family, or duly authorized representative. Then, the next most important is Book 5, and also Book 3, and Book 1. Ang pinakawalang kwentang libro sa labor code ay ang Book 2 at ang Book 4, ang Book 7. Walang masyadong tanong dyan. Ang tanong talaga, 80% of the questions are here in the 4 books. So since you do not have enough time, you focus on the most important ones. Okay? Do you think that this is useful if I tell you what are the most important articles of the labor code?
Very useful,
Wala.
attorney.
Yes,
Very
yes,
useful.
attorney.
Oh. So, sa next meeting ko na sasabihin yan kasi parang kumukunti yata yung umaatin Attorney Wagas. Ano ba ang problema? Hindi ba nila nagustuhan
ang uban attorney nag-message na ko na nihinay ilahang internet connection maong na-disconnect.
Tagae og libreng internet. Tagae laptop. Okay, so it's 8 o'clock already or about 4 minutes away. I want you to bago kayo matulog, 44 kayo ha, or 42 na lang, ilagay nating 40. Pumunta naman kayo sa YouTube at saka mag-type kayo ng USEC JBJ and then mag-like ba kayo doon, mag-comment kayo kasi nandoon yung mga video ko, yung mga lecture ko at nandoon na rin yung buhay ko kasi may mga tribute doon sa mga OFWs nagbigay ng tribute sa akin. Tsaka yung trip to Europe, my family and I went to Europe last year. Last year, nagpunta kami sa Europe, sa Fatima, sa Lourdes, sa Rome. That was the 3rd time we went to Rome. Nagpunta kami sa Spain, nagpunta kami sa Portugal, sa France, sa Germany, sa Switzerland. Marami kaming pinupuntahan. So nandoon, kung gusto lang niyo maglingaw-lingaw, pero kung gusto niyo matuto, nandoon talaga ang video sa mga lecture. At every Monday naman, on Thursday, may libre akong webinar which is about labor law. Ang topic namin this coming Thursday is napaka-exciting. You know what? It's about sexual harassment. And next Monday, love, sex, and romance in the workplace. LSR, love, sex, and romance. Ang employer ba may pakialam kung ma-inlove ang isang estudyante, ang isang professor na in love sa kanyang estudyante? Yan ba ay illegal? Immoral ba yan? Meron na mga desisyon ang Supreme Court sa mga masilang usapin na yan. At kayo ay makikinig sa aking webinar na libre, wala namang bayad dyan. Kung kailangan nyo, mag-text kayo sa akin. Ang number ko ay 0917. I will repeat. 0917 8606 997. Tapos ang email ko ay joseposbjimenez@gmail.com at attorney joseposbjimenez@yahoo.com. So, kung gusto talaga niyong matuto kayo ng malaliman, mabuti na yan yung mag-attend kayo. Kung may panahon naman kayo, wala kayong ginagawa, hindi kayo nag-TikTok, hindi kayo nag-Facebook, is mag-focus na kayo sa inyong pag-aaral kasi malapit na ang araw ng paghukom. Mabuti nga kayo na-postpone yung bar eh. Kung hindi na-postpone ang bar, so that means you have more time to prepare. Sa inyo na libre, na wala kayong bayaran, na mag-lecture sa inyo, na kinasing-kasing ang lecture, na for 36 Mondays. Attorney Wagas, this has never been done in the 100 years history of UV. It's
Yes,
only
attorney.
now.
Yes, attorney. And we're very thankful gid kayo, attorney.
Attorney tas Ginoo, magpasalamat. Og kamo nga naminaw karon kanako unsa man inyong ikasulti. Sulti mo bisag gamay na lang pulong, no? Pakonsuelo ba, no? Ikaw Voltaire, unsa man ka diha?
I'll ask lang ko attorney ba regarding sa quit claim, if ever ang employee kay dili mo sign sa quit claim, maka-receive ra gyapon siya sa last pay during resignation?
Well, the signing of a quit claim is just an assurance of acknowledgement. Kung halimbawa ang wording ng quit claim is very unfair, statement that this signature is only to acknowledge receipt of the amount.
Oo.
It does not mean that he is waiving all his rights. Kasi minsan kasi, Voltaire, yung the way the waiver is written is really unfair to the other side. Hindi ba fair? Kasi contract of adhesion yan eh. Pwede rin niyang sabihin, receive under protest. No.
Receive under protest or receive last pay lang.
Para bang may reservation siya sa kanyang he may raise issue about it.
Yes, attorney.
Any other? Why are you working, Voltaire? Are you working?
Attorney niya. Wala raman kinang namgoy mga na quit claim ba? If ever na yung mga quit claim nga resignation.
Di bale, basta ayuha lang po nga fair po ang quit claim ba? Dili ba masyado kayong iniipit natin yung mga sinurinder na sila sa iyo.
Thank you, attorney.
Ikaw, Mr. Carion, anong masasabi mo?
Napugoy question, attorney.
Unsa man?
Excuse me. Karon majority sa atong mga negosyo karon, attorney ba? Kasagaran di gud sila mo follow sa labor standard.